Good afternoon, everyone. I'm Anusmita Roy, and I'm here to provide a short video on the topic remuneration of directors. So, we'll proceed with the meaning of directors. That is, the members of the board of directors who are in charge of supervising, managing, and directing a company's activities are known as directors. There are three basic forms of directors who exist in a company, which are as follows: that are the managing directors, executive director, and non-executive director. Managing directors are those who has been given significant managerial authority over a company as a result of a company's bylaw, a contract with the company, a resolution adopted at the general meeting of the company or by the board of directors. Executive director, on the other hand, serves as the organization's director full time. They are responsible for running the business and are held at a higher level. They must use caution and diligence at all times, as it is obvious. And finally, the non-executive directors. And non-executive directors is not involved in the day-to-day management of the company. They could participate in the formulation of plans or policies and push the executive directors to make choice that is the best for the business. Now we'll proceed with the meaning of remuneration. Under Section 2, Subclause 78 of the Companies Act 2013, remuneration is defined as any money or its equivalent granted or delivered to any person for services done by him, which includes prerequisites as in specified in the Income Tax Act 1961. As a result, any payment made to a director in exchange for services given by him will be considered remuneration, and any benefit supplied to a director by the business will also be considered as a remuneration and must be factored into the director's compensation. Remuneration to directors of a company. The limitation under Section 197 and 198 of the Companies Act 2013 states that it only applies to management compensation or other compensation paid by a public company. Therefore, any compensation provided to or due by any private company to its directors must be outside the scope of the aforementioned clause and shall not be taken into account when determining the maximum compensation that a company may pay. Limitations to remuneration or remuneration to directors of a company. There are few limitations, that is, the entire management compensation paid by a public company to its directors, including the managing director, whole time director, and its manager in respect of any financial year, should not exceed 11% of the company's net earnings, according to Section 197 of the Act. As a result, public company is as a result, the company may is only permitted to pay its executive and non-executive directors compensation that does not exceed 11% of net earnings and will only with the previous consent of the company's members expressed in an ordinary resolution. The payment due to a director includes the remuneration payable to him for services provided in any other capacity. This indicates that if a director is paid for services other than directorial duties, the amount must be included in the overall pay in order to determine the 11% net profit maximum specified in Section 197, Clause 1 of the Act. The sole exemption is when payment is given to a director for professional services supplied to the company without any restriction is not included in the limit. If the following two requirements are met, the services provided are of a professional nature, and the Nomination and Remuneration Committee believes that the director has the necessary qualifications to practice the profession. If the company is not required by Section 178 to have any such committee, the board can form this view. Important points to remember considering regarding remuneration of directors of a company is that the director's remuneration shall be decided by the articles of the company, a resolution passed by the company. If the articles of the meeting necessitated it, special resolutions must be adopted. The remuneration due under these regulations must also account for the remuneration due to those serving in any other roles. Exemptions are available, though, if the services were provided in a professional capacity and the nominating and remuneration committee or board of directors consider the director has the qualification required to perform this profession. So, and there is also the director's fees. A director's fees may be paid for attending meetings, but these payments cannot go beyond the established threshold. Dif- Different fees may be set for different sorts of companies. You can pay by monthly as a particular percentage of the annual net profits, or by using both the above mentioned techniques, whatever is feasible. Remuneration of independent directors. The independent directors are compensated in accordance with the board's approval with respect to profit related commissions, sitting fees, and reimbursement for travel expenses. He will not, however, be eligible for ESOP. Refund of excess remuneration. Any excess remuneration that a government gets beyond what is required by law must be returned to the business or held in trust for the company. This recovery cannot be waived without the central government's consent. Disclosure by a listed company. In addition to other required information, every listed company is required to report the ratio between the compensation paid and the median employee's compensation. Finally, is insurance. That is when a company covers the actions of its employees against carelessness, default, misfeasance, breach of duty, and breach of trust. The premium paid for such insurance is not considered part of the director's remuneration unless the director is found to have committed a crime. Any managing director or full-time director who receives a commission from the company is also eligible to accept remuneration or a commission from its holding companies or subsidiary as long as they mention it in the board report. So finally, in the conclusion, I can state that a company's directors or the persons in charge of its activities are accountable for making sure that everything runs smoothly. They must work together while looking out for the interests of the shareholders and stakeholders. The corporation must carefully evaluate appointment, remuneration, and other associated issues of the directors because the success of the business depends on their competence. Thank you for watching.